Any mention?
No mention. Hello. No mention.
May please, Your Lordship. Lordship, I beg to mention item number 39.
39.
39. Lordship.
Hearing list.
Hearing list, Your Lordship.
Yes. Hasina Khatun.
Yes, Lordship.
Put
Please,
other
madam.
side.
Your
objection?
No, no objection.
How long?
2 weeks, Your Lordship.
2 weeks.
Lordship.
Yes.
Oblige, Your Lordship.
Hasina Khatun.
Your Lordship, I beg to mention item number 37.
Put other side. Is she? No objection?
No objection, Your Lordship.
Yes.
May please, Lordship. Lordship, I beg to mention item number 36.
36.
Yes, Your Lordship. Lordship, we are yet to receive the records.
Okay, after 2 weeks for production of records. Yes.
May I please, Your Lordship, I beg to mention item number 38.
Shobha Gupta.
Shobha Gupta, Your
Put other
Lordship.
side.
May this
Yeah,
matter come
objection?
out
No, Your Lordship.
after 2 weeks.
Yes.
After 2 weeks, Your Lordship.
You would Mr. Changriso?
Yes, Your Lordship.
And she's also together?
Yes, Your Lordship.
Very good. 2 weeks, yes.
Please, Your Lordship. Lordship, I beg to make a mention of item number 28, Lordship.
Isn't he hearing this?
Lordship.
28. Prakash Chandra?
Lordship.
Oh, where's Mr. Paul?
Lordship is currently out of station, Lordship.
It's a contempt.
What to do?
So there are two matters segregated. One is reserved to judgment.
Yes, because we're waiting. I thought we'll let them conclude the other.
So they have to give where we have not complied with that. They have to give us some evidence that where
Yes,
we have
yes,
not complied with it.
You remember that? Where's MSR Data? Or Thapa?
Lordship.
Thapa not here. What to do?
February
Okay, 2 weeks. Yes, February. Yes.
after
30 also will go to February. Yes.
30, 31, 32.
31, 32. Right? Yes. Yes.
Oblige.
Oh, may I please, Your Lordship. Item number 33. It may come today. I am not ready, my lord. After a week only.
Not ready? Why? You're a seasoned counsel. You don't need to look at the file also.
Anyways,
Right.
it's a long time back.
Long time since you look at any file. Okay. Yes. No objection.
Objection, Your Lordship.
Yes.
Supplementary list item number 1.
What is this?
Transfer, my lord. Transfer.
Transfer.
Yes, my lord.
From which court to which court?
From the Sessions Court to the
But
District Council.
Mr. M. Sharma, if you notice, who's for this council? MS R. Colony is present. We have number 1 of the notice. Notice 2. You've served notice to KCDC? Yes. You've served?
We have served.
You've served?
No, we have not served one. We'll serve a copy to them.
Number 2 is within 3 days. We'll list when the other matters listed.
Today, my
Today,
lord.
Today, my
Today.
Item number 17 onwards, my lord.
Yes.
Oblige.
Item number 2.
What's this? Section
Application
11.
for appointment of arbitrator under section 11.
You have a list.
We have
No, but
given the
the list-
names.
Did it?
The list is expired, my lord.
No,
Then-
this is from the fresh list we have given the names.
What fresh list? Where have you given the name?
Yes, we have suggested the names. These are from the
Where is that?
new list. It is at page 13. You know.
Fresh list.
As far as I know, my
Yes.
lord, there is no fresh list.
There's no fresh list.
We have got that fresh list. We have taken out from the net. This is that fresh
The
list
special agent following names are
from the fresh
Ajay
list.
Kumar Agarwal.
Yes.
You just get instructions. Yes, heard MSP.
Anyone from this list can be.
Yes.
Anyone from this list?
Yes, so also you should notice Dr. N. Muzika blended DSGI with
Jana.
yes, MS also is present. No notice is required. Stop. It is submitted in this application under section 11(5) bracket 5 and 11(6) of the Arbitration Completion Act 1996. It's submitted by the Senate Senior Counsel that the names which have been indicated para 12, one of the names will be appointed as arbitrator. Stop. But in Musica, then its Senior Counsel submits that at present there's no list that is valid.
Yes, my lord.
Please allow to obtain instructions on the names that have been supplied. List after 3 weeks.
2 weeks? Special.
3 weeks?
6.
Item number 3 of list.
Please, Lordship. No, so this is
What is this?
non-releasing of the non-releasing of the person, my lord. My husband was regularized.
You've been regularized?
Yes. However, I
You
was
keep
died.
running. Just catch your breath, yes. Okay.
So
Take
the,
deep breath. Now you caught your
Yes.
breath.
yes, my lord.
Okay.
So the this is husband. This is employee was working was a peon. Then he was regularized. Then he died in hardness. So the petitioner here is the wife of the deceased employee.
He died on.
He died on the happen
He was a casual worker. Then he was made an RCW.
Yes, he was a regularized. Letter is there. Lordship of yes. That is page 29.
So he was regularized as an office peon. Or RCW
Yes. It is that page 29 is there, Lordship. The post here we will observe we can post of peon as a peon. As a peon. Page 29, man. It is that absorption.
Okay. Yes, I can please.
Yes, and
So
then
since he died, your petitioner got any pension? You take instructions.
Yes, madam.
Yes, but with the PT Sama Leonard Council petition, you should notice Mr. Kibaki KP Prasaji is present example we have 1 to 4 and MSEB Pasa 5 no is required just after 2 weeks instructions or affiliate.
Daily list item number 1.
Please, Your Lordship. Your Lordship, I pray that this matter may be taken up tomorrow.
Where's Mr. Yupin?
It's out of session, Your Lordship.
There's a fresh matter.
Yes, Your Lordship.
What's your name?
B.L. Lankoy, Your Lordship.
Your?
B.L. Lankoy.
B.L. Lankoy.
Yes, Your Lordship.
Here is an application seeking review of the settlement order dated 18/7/2025 passed by this court in WC number 106 of 2025. Issue notice issue notice returnable in 2 weeks just thereafter.
Obliged, Your Lordship.
Item number 2. Please, Your Lordship.
Yes.
Your Lordship, we have just received a copy of the affidavit filed by the JHDC, Your Lordship. They come after 2 weeks, Your Lordship.
Well, this matter can be disposed of there before this honorable court for only one reason, my lord, that two matters which have been decided in the district council should be tagged together. These are two different matters, my lord. Why?
Well, remember, let the senior is not here. Yes.
Let it come after a week, my lord, because there also the matter is getting hold, my lord. That is what is my instruction. Let it come after a week, my
Your
lord.
Lordship, but this is in respect of the Ajipse Akhang because both the clan are involved, Your Lordship.
Two different subject matter is going on before the district council. How, my lord, this matter can be tagged together? Why are two different parties, not even the same parties? If it is the same parties, we can tag.
Who's leading the matter?
Your Lordship, Mr. Momen will be in a better position.
Where's Mr. Moment?
Your Lordship, let it come after 2 weeks, Your Lordship.
After a week, my lord.
One week, my
After
lord.
1 week, my lord.
After 1 week, my lord.
MS some of the subjects that. Sorry, that you have to file by the responsible and received.
My lord,
Rejoinder.
Lordship, I have to seek instructions. Let it come after a week.
what has fallen from my
Then come
lord
to a
on the
week.
last
If it is
occasion?
allowed 1 week's time to file rejoinder if.
What has fallen from my lord on the last occasion, my lord?
To file rejoinder if required.
Yes, well, what has fallen last time, my lord? That my lord has suggested to the petitioner that on the same date the matter can be taken up, but cannot be tagged together, my lord. That was the matter.
Yes.
But tell Mr. Moment if he remembers what this relative report.
After a week, then we
After a week, yes.
My lord, highly yes.
Much less, Lordship.
Item number 3.
May I please, Your Lordship? Your Lordship, I pray for some accommodation in this matter. I have filed the adjournment, Your Lordship.
Mr. Pandey is arguing this matter?
Yes, Your
Who's on
Lordship.
the matter?
Mr. A.S. Pandey, he has some personal difficulties, Your Lordship.
Yes. For adjournment. After
2 weeks, Your Lordship. 2 weeks.
2 weeks won't be, I think won't be enough. He's getting married, right?
Yes.
Yes, so
But
3 weeks.
any date after 24th, my lord, will be convenient.
Huh?
After 24th, my lord. 24th plus 24th. The next
So
week,
he
my
won't
lord.
be, I think first week December.
Lordship. Lordship.
Lordship.
Item number 4.
Lordship. We've received the affidavit, Lordship. We'd like to file a rejoinder, Lordship.
What rejoinder?
They file a counter affidavit to our
What's the matter about?
appointment of arbitrator, Lordship.
Okay, yes.
My lord, this petition is not maintained, my lord. My lord, the clause says that either the work has to be completed or it has to be terminated, my lord.
There's no subsisting, there's no.
Now, we issued a notice for termination, my lord. They've gone to a commercial court and obtained a stay on that, my lord.
Where's Mr. Khera?
He's on legs, Lordship. He's unavailable today, Lordship.
When was the affidavit received by you?
2 weeks back, Lordship.
2 weeks back? No way asking for time now.
We had just
You
perused, Lordship. We
you
just
know
want-
the matter?
No, Lordship. I just want to bring on record, Lordship, certain documents.
So as long as
If that is the case, you're seeking this Section 11 application.
Lordship.
At the same time, you went to commercial court.
and obtained a stay, my lord.
After it's on a bank guarantee.
No, my lord. There's a stay on the termination, my lord.
Then
Lordship, just allow us to file rejoinder, Lordship. We'll bring on record.
next week.
1 week.
Yes, Mr. Karkarang please that some compensation will be given as arguing counsel available. This matter next week, yes.
Lordship.
Item number 5.
My lord, contempt petition against the order dated 18 March 2025, my lord.
Where's the affidavit?
My lord, can you see last order, my lord?
Yes. It's ready?
The last order.
But the affidavit is because we have nothing much to say, my lord, except that SLP is in file, my lord.
My lord, the SLP is still in defective, my lord, from last 2 months, my lord. They are not.
That is the tactic. So
No, not tactics.
filing keeping it in defective. How many petitions are here?
Will be
My lord,
200 something.
600.
600.
Sorry, my lord, 607, my lord.
The similar writ petitions are also filed, my lord. It came up yesterday. It was granted us till February, my lord. Those matters.
Warrant officer entry grade.
Yes, ma'am.
My-
To the clerks. To the clerks. So relying on this, they filed another writ petition. There are 200 some petitions. Relying on this judgment, they filed another petition that came yesterday, man. There are 200.
Appeal, you mean?
So they filed another writ petition for the leftovers, man.
Before court came here?
Yes, man. The matter listed.
They say that
Yesterday, that matter.
No, my lord.
they are covered.
Mr. Kumar is here. Mr. Patel.
Can we file after? Whatever it is, just to be a record. Yes, for a 2 weeks time, whatever you have to say. But then otherwise, contempt have to await compliance. That's all.
Yes.
3 weeks only.
3 weeks, okay.
Item
My
number
lord, 2
6.
weeks are enough, my lord.
No point, Mr. Kumar.
It's under the to
Dr.
carry out the
Murthy
exercise.
also.
My lord. Much
Item number
obliged.
6.
As per the last order, Your Lordship was pleased to issue notice to the former secretary, Your Lordship.
Yeah. Officer indicates that the suspicious report not been received from the senior superintendent of post office. List after 2 weeks.
2 weeks, Lordship.
Otherwise, have to go through the police.
Lordship, item
34 and 35, Your Lordship.
35 as well.
34, 35.
After 2 weeks, yes.
Apply, Your Lordship.
Seven.
Please, Lordship. This matter, Lordship, had filed a miss case for preserving of CCTV. They had filed
They
a
said you don't have CCTV anymore.
Lordship.
Then last time nobody appeared.
Yes,
Are you
Lordship.
interested in proceeding this matter?
Yeah, Lordship. Just a miscommunication the last time, Lordship.
What do you mean miscommunication?
Between our colleagues, Lordship, for appearances. Lordship, kindly post it for hearing, Lordship, on miss case.
Yes, but
Okay, yes, after 3 weeks, then.
this is matter for hearings on the
Apply,
plea
Your
parties.
8. Item number 8.
Lordship, my rejoinder is ready, Lordship. I'll file during the course of the day, Lordship. File.
Yes, Mr. S.E. Sheikh submits that the agenda after we file the course of the day. This is the matter for hearing when?
Any day, Lordship.
On.
9.
Yes.
What is for the affidavit? I'm praying for some more time.
When does this matter file? It's 352. 2 weeks for the time it's prayed. Also, affidavit.
10.
May it please, Your Lordship. Your Lordship, in this we've already filed a affidavit, Your Lordship.
There's no one in place of MS Esbrazaji. He's alone here.
My lord, she is still under treatment.
No, I understand. Is he alone in this matter?
No, my lord, as per the causes, I can see there are 3 other people.
What about you're paying for 3 and 4?
Yes, Your
What
Lordship.
about number 2? Number 2 is whom?
UGC, Your Lordship.
UGC. Then number 1?
Union, Your Lordship.
Union of India, my lord.
No, appears Union of India. Not National Party. Any idea?
Sir Devnath is there, Your Lordship.
Yeah?
Union. Sir Devnath, Your Lordship.
What Mr. Devnath doing sitting there? Please come forward. Yes. Are you filing affidavit? Yes, Mr. Devnath, the court can't wait for you forever. Are you interested in filing affidavit here? Don't know. He doesn't have the file also. As you have, how much more time require?
I have already filed, Your Lordship.
There's MS Ibla for response 3 and 4 submits affidavit and we have said response only been filed. None appears for response number 2. Mr. Devnath will seek instructions whether if affidavit necessary. Just after 3 weeks. Yes.
There is similar matter up to 13 Your Lordship. Then
Up to 13?
No,
13 and
10, 13 and 14, Your Lordship.
Same order, same respondent.
Yes, Your Lordship.
Okay.
Your Lordship, in 30.
They are asking the relief only for response.
After you don't even know what the matter is about, now you're saying after all has been passed. Next item.
Your Lordship, 13, 14, we yet to file affidavit. Your
13,
Lordship.
14, not filed.
No, Your Lordship. We yet to receive instructions.
You have respondent number?
3 and 4, Your Lordship.
3 and 4, and same UGC is there also.
Yes, Your Lordship.
None appears for 2. 1, you don't file affidavit.
There is no need to use.
Yes, in 13, 14, Mr. R. Devnath For respondent 1 submits that no appeal forthcoming to the respondent. Stop. None appears for respondent none appears for number 2. Stop. Ms. Ibla appears for and allowed further 2 weeks time to file affidavits on behalf of respondent number
3 and 4, Your
3
Lordship.
and 4.
Obliged, Your Lordship.
11.
Yes.
Communication of ACR. My lord, the representation is already filed, my lord, because I have not been also told as to which particular ACR is lacking. And in Annexure 3, my lord, I have already filed a representation that this should be expunged, my lord. That is yet to be considered. So my humble and limited prayer now is that that should be considered, my lord. My representation at Annexure 3.
Could have been disposed, my lord. The only difficulty is I don't have the date for which year.
You get the date.
Even I don't have the
So the subject matter issue is short.
That has not come on record.
Yes, yes. Though the subject matter issue is small, however, due to unavailability of the exact date for which the ACR have been communicated.
Yes.
Not communicated.
Not communicated.
Counsels for the parties permitted to seek instructions just after 1 week.
Yes.
Yes. We'll dispose of next date.
11, 12.
My lord. 12 also same, my lord.
15.
Obliged.
15.
Yes.
Your Lordship, the status report for the notice is still pending, Your Lordship.
Yes, what instructions have you received?
Lordship, we not receive instructions yet.
It matters urgent.
Lordship, grant us 1 week time, Lordship.
We'll call your CFO.
Lordship, we'll take instructions.
Yes.
1 week time, Lordship.
When did matter come up last? Came on 29th October.
29 October.
Then, in spite of the court expressing concern with regard to the gravity of the matter, no instructions are yet forthcoming from respondent 1 to 5. Stop. Mr. Emmanuel praised in about 1 week's time to come with instructions, feeling which a responsible officer will be present in court to answer the court's queries. Yes.
We'll come with instructions after 1 week, Lordship.
If feeling which, that's the thing.
Lordship.
Yes. Just after 1 week.
Yes, similar.
16 is
it's a different matter, Lordship. 16.
even the status report is still pending.
I'm 16. What is this?
Just regard the.
Vaishnav, what's this?
This concerns the same forest in the earlier matter, Your Lordship.
No, Your Lordship. It's regarding notification issued by the GHEDC.
Regarding
the jurisdiction, Your Lordship, of the Nongjini, Your Lordship.
Boundary dispute?
No.
Page 88,
the notification states.
Let's see.
Yes.
Okay, the third Mindri should be within Natyang.
Yes.
The other matter is also pertains to Tharmendra, Your Lordship. They're seeking deforestation of that.
That's regarding the forest, Your Lordship. This
concerns the same village, Lordship.
And this one, you want to be within Natyang.
As per instructions, also did not receive yet, which is my point that yesterday.
Then when they instructed you, we didn't ask what's the case about.
We just yet to execute our Bakalamas, so today we'll be filing.
What public hearing was then, 29 November 2024? Has it come on record with an appeal?
No, Lordship.
This notification says, upon a thorough review on the materials available in the record and taking into consideration the will of the inhabitants of Hadmantri Valley ascertained through a public hearing which is conducted on 29 November 2024. You have a copy of that?
There's only statement, Your Lordship.
No, you have a copy of this public hearing?
Lordship, page 94, Lordship.
The entire public hearing?
It's enclosed at page 94, Lordship.
Okay. 94. Oh, it's here, page 97. The translate copy.
97 is translated.
Who was here? You were present in the meeting also.
Yes, Your Lordship.
Now you challenge. Why you challenge this notification? You have the will of the people.
Your Lordship, the Tharmari village has always been under the Ilaka Nongjing, Your Lordship. Even in the list of constituencies, page. Page 54, Your Lordship. Serial number 20, Your Lordship.
Page
54.
Have you file affidavit?
I'll file my affidavit.
So now it's under nothing.
Yes,
Order.
after the order.
This is January 2025, Your Lordship, the notification.
Before that under Nongjing.
It was always under note.
There were some proceedings, Your Lordship. I'll file my affidavit.
Yes, Mr. Karakrang, and appeal on behalf of the respondent number 6 today. Number 5.
5 is Dalai, no.
You're going for Dalai also?
Yeah, just for 6.
You've taken steps?
Yeah, I've taken steps. Just the report is still pending, Your Lordship.
On Dalai?
Yes.
Yes, Mr. Arkakrang and appearance today on behalf of respondent number 6. However, on behalf of respondent 5, the status of service has not yet been received. Stop, Ms. Nekvara, Ms. Emil Nokur appearing for response 1 to 4, as well as Mr. Karakrang for 6. Pray that be allowed 2 weeks time to file affidavit. The result is thereafter for affidavit and for appearance and for service report on respondent number 5.
17.
Matters.
These are all transfer briefing 17.
Orders, ne?
Lead matter is item 21.
Yes.
My Lord, in view of yesterday's judgment order in that,
It has passed certain order yesterday in division date.
so I think that also will have a bearing on this case. We have yet to get a copy of that.
See, the thing is that, anyway, let's discuss it.
Yes.
It's only 5.3 or 5 paragraph 5.3, 5 sub paragraph 3 says that will not apply. But then that the courts for the exception given in the notification has been noted by the court.
Has not
that all. Yes. Another paragraph 5 investment of powers by the governor under CCPC to these
So that judgment yesterday would have a bearing on this.
Milord, CRPC has been notified and district and session judge will have power, Milord.
No, that's fine. That is fine. That is
to try the cases. Yes, that
has been settled by the court yesterday. Has said that no, the order yesterday. Yes.
One more sentence, Milord. One more sentence, Milord. That district and session judge will have power to try the cases, Milord. Their case is that district and session judge has no jurisdiction to try the cases. Therefore, transfer those cases to the courts constituted under para 5, Milord. See, the transfer can take place only when the district and session judge lacks jurisdiction. My case is this.
No, I leave that aside for the time being, Mr. Advocate General. The only thing is now, see, the judgment yesterday by the division bench has upheld the validity of the notifications, extending the CRPC now BNSS whatever, into the other courts, investment upon other courts. Well, at the same time, because that exception been carved out, that the functions of the district council courts will continue under para 4 under 4 and 5. So that exception carved out. So that has been noticed. That has been noticed, and anyway, you go through the judgment.
Yes, we'll go through the judgment.
As reported that a judgment recent. Mr. Changresu was there.
Yes, I was.
Yes, recent judgment has been passed yesterday itself with regard to the subject matter in issue. It's just a matter of the 2 weeks to allow the petitioners to examine the same and its impact on the present cases. Yes.
Supplementary list. Item number 4.
See, Dr. Mozika.
Yes, ma'am.
Apart from that Bengal judgment, all those cases, all the people appointed prior to Umar Devi. In all those cases.
No, I'll place those aspects.
Milord, I have one compilation, Milord. I can, Your Lordship is going through those judgments. I can give the compilation in advance, Your Lordship. A compilation is there, Milord, of the judgments on, even recent judgments are also there, Milord. So Your Lordship may have the compilation on record, Milord. So Your Lordship will get time to go through the judgments relied by them.
Very interesting matter.
Yes, Milord.
Difficult to.
It's a balancing act, balancing of equity, Milord. That is both sides are having some point.
Exactly. Yeah, it's balancing equity. Dr. Mozika, over and above this, the judgments, are you relying on any more?
Yes, ma'am. I have another compilation.
And where's the chart?
The chart, if there are more than 500, is in the process, my lord. Maybe in a day or two we'll complete that. Because for every petitioner, because
That will be required.
You have an army of juniors. You get enough.
they're working on it, my lord. But because 500 petitioners, if one takes 5 minutes also, it's taking a lot of time.
Because, and I would request Dr. Mozika to supply a copy of chart in advance so that I can also
Yes,
go through
yes,
the chart.
we'll do that.
And
No, because the exercise we have to do, Dr. Mozika, is that based on the chart, we want to at least categorize, by year wise and post wise, how. So that
My lord, yes, my lord, what I was requesting, my lord, what I understand that GNM, ANM and paramedics, my lord, those are taken up first, my lord. That will short out about 50% of the cases.
As cursory view shows that they are on a different footing. So they'll be taken differently. Whether they take up first or these other meetings make no difference.
Yes,
because we are going with ad hoc, like you're seeing the upon against sanction post, correct? Serving there for over 10 years. Now we have to look only at that and the advancement of law.
Yes.
And whether we can, I don't know.
Milord, the appointments are without impeachment, without recruitment rules, Milord, and without.
No, let me place the facts. On what basis a learned AG is saying that?
I will go into this aspect. This is my submission. I'm
Yes,
not
yes.
joining my friend on this issue, Milord.
Yes.
My submission is that.
Maybe we can import the from industrial law with regard to the days of service.
Retrenchment principle 25. 25. That is also a tool to balance equity. That could be possibly a tool to balance equity. But chart would be required.
Yeah, I'll place the chart. If AG is not ready, so say directly that he is not ready. He is taking some time.
No.
Otherwise, I'm ready. Yes.
I'm ready. Please go ahead. Please, I'm ready. I'm not.
Because on mic you're very loud, and it becomes difficult for me to.
Yes.
On mic, learned AG is very loud, so.
The mic is very loud.
Yes.
I have to turn up the volume of the mic. See, this volume.
But I'll compile.
Volume is not important. It's the content.
Yes, madam.
Yes.
Heat without
like my
light.
old seniors who say,
Heat without light.
Yes. No point in only having heat without any light. So if you only have heat without any light to show, then there's no point. Yes.
Milord, counter has been filed in the item. Milord is
438.
Item 4, Milord. But that is the lead.
So, Malad, that is another aspect, whether learned AG is filing counter affidavits in some other matters or not. If it's not filing, that should be recorded, Malad, that is not filing affidavit in other matters. Because what will happen, Malad, what will happen, I'll just submit. They should not take advantage later on that they did not file affidavit in other matters while filing appeal, Malad. Because the facts are different in all the cases. We took the pain to file maybe 100 writ petitions, Malad. They should also, either they take the pain or they say they are not filing, Malad. Because that is not a representative case, my lord. That item number 1 does not cover all the cases, my lord.
that should not be construed adverse to my stand, my lord, because then in that case I will file in.
See, with Mr. Arpejal, this court under impression that we are going on a general, like on the legal principle, the law surrounding this situation and what happens. So regarding the particular facts of every case, now we want a chart to see how long they work. So that we thought, that
my only concern is, my lord, they'll say later on that they'll not given a chance, they didn't file an affidavit in other matters, my lord. And they'll take that advantage, my lord.
If I can summarize my stand, my lord, my stand in all these cases would be one, that their recruitment, there is no advertisement before the recruitment, one. Two, my lord, that the recruitment is not in terms of statutory rules. Three, my lord, their recruitment was officiating and temporary and stopgap, subject to regular recruitment. These are the three cardinal arguments which I will be taking.
Right. Now, then the counter argument, legitimate expectation, whether they acquire a vested right, whether they pose against sanction, whether sanction pose.
No, my lord, the first point learned AG is taking the problem starts there itself, my lord. Learned AG is saying that there is no advertisement. Now I'll place about 80% of the cases are advertisement, my lord. Of course, advertisement for undergoing the course, my lord. Now, whether that will amount to backdoor entry, whether a fresh advertisement for recruitment is necessary or not, my lord, the lords will have to examine them.
How many cases through advertisement?
But advertisement for undergoing the course, my lord.
How many?
About 80% of the cases, my lord.
And then a bond sign after that.
Bond sign after that, my lord.
No, my lord, let my friend place the.
You start, yes. Actually,
advertisement shows, my lord, it is a case of self-employment. It is a case of self-employment, not.
Let me complete my argument.
Let him argue. If necessary, you can file affidavits, but then that's yes. If you start.
Or I will file the affidavit, my lord, if my friend can categorize that this is the lead matter in this matter, I will file affidavit accordingly, because there are so many matters.
We are not saying any lead matter. So I'll place these decisions, my lord, today. Not many.
Piecemeal. Yes. Yes. Have you finally joined up this affidavit now?
No, my lord.
Yes.
Well, first I'm citing 2000 volume 8. This is a constitution based decision, Rudra Kumar Jain, para 15 to 20. What is the ad hoc appointment? Basically, it touches on that, my lord.
Yes.
Para 15 onwards, I'll read till 21. Para 15.
Yes.
So far as the terminology used in Singla case, namely ad hoc, fortuitous.
You'll call this compilation 2.
But I'll compile it together, my lord. At the conclusion, I'll
given the first compilation was Jagu and all.
Compilation 2, my lord.
Okay. Yes.
So far as terminology used in Singla case, namely ad hoc, fortuitous, and stopgap, the same is quite familiar in the service jurisprudence. Mr. Rao, appearing for the High Court of Delhi, however, contended before us that said terminology should be given the same meaning as was given in Purushottam Lal Dhingra Union of India. In Dhingra case, the court was examining whether the removal of an employee can be held to be penal and whether Article 311(2) of the Constitution can at all be attracted, and the court also observed a certain amount of confusion arises because of the indiscriminate use of the words provisional, officiating and on probation. We do not think that concept or meaning given to those terminology in Dhingra case will have any application to the case in hand, where the court is trying to work out an equitable remedy in a manner which will not disentitle an appointee. The benefit of this fairly long period of service for the period of seniority, even though he possesses the requisite qualification, and even though his appointment has been made after due consultation and approval of the High Court. The term used the three terms ad hoc, stopgap, and fortuitous are in frequent use in service jurisprudence. In the absence of definition of these terms in the rules in question, we have to look to the dictionary meaning of the words and the meaning commonly assigned to them in service matters. The meaning given to the expression fortuitous in Stroud's Judicial Dictionary is accident or fortuitous casualty. This should obviously connote that if an appointment is made accidentally because of a particular emergent situation, and such appointment obviously would not continue for a fairly long period. But an appointment made either under Rules 16 or 17 of the recruitment rules after due consultation with the High Court, and appointee possesses the prescribed qualification for such appointment provided in Rules 7 and continues as such for a fairly long period, then the same cannot be held to be fortuitous. In Black's Law Dictionary, the expression fortuitous means occurring by chance. A fortuitous event may be highly unfortunate. It thus indicates that it occurs only by chance or accident which could not have been reasonably foreseen. The expression ad hoc in Black's Law Dictionary means something which is found for a particular purpose. The expression stopgap as per Oxford Dictionary means a temporary way of dealing with the problem or satisfying a need. The Oxford Dictionary, the word ad hoc means that a particular purpose, especially in the same dictionary, the word fortuitous means happening by accident or chance rather than design. In P. Ramanathan Iyer's Law Lexicon, the word ad hoc is described as for particular purpose, made, established, acting or concerned with a particular and or purpose. The meaning of the word fortuitous event is given as an event which happens by a cause which we cannot resist, one which is unforeseen and caused by superior force which it is impossible to resist, a term synonymous with the act of God. The meaning to be assigned to these terms while interpreting provisions of service rules will depend on the provisions of that rule and the context and the purpose for which the expressions are used. The meaning of many of these terms in the context of computation of interstate seniority of officers holding cadre post will depend on the facts and circumstances in each case. But I can skip this part, my lord.
Yes.
Para 20.
Yes.
In service jurisprudence, a person who possesses the requisite qualification for being appointed to a particular post and then he is appointed with the approval and consultation of the appropriate authority and continues in the post for a very long period, then such appointment cannot be held to be stopgap or fortuitous or purely ad hoc. In this view of the matter, the reasoning and basis on which the appointment of the promoter is in the Delhi High Court, so and so. So, my lord, basically it tries to define what is ad hoc. Ad hoc means for a particular purpose. Now, our appointment, my lord, because I am preparing the chart and I am including in the chart what is the nomenclature of appointment, my lord, whether it is ad hoc or officiating. Nowhere ad hoc word is used. And lordship will see the office memorandum impugned only uses the word ad hoc. It does not use the word officiating, my lord. It does not use the word temporary. Only word used is my lord.
Memorandum.
It only uses the word ad hoc, my lord. If lordship, I can take a lordship once again through the my lord. Only word used is ad hoc.
Okay.
Now, whether our appointment can be categorized as ad hoc, my lord.
So you want to go to very root. The meaning of what is ad hoc means and whether if you can prove your case, then they don't come under the definition.
They don't come within the definition of ad hoc itself, my lord. So, in fact, especially in case of ANM, GNM, and paramedics, my lord, and in some cases of water resource department also, I am seeking a declaration from your lordship that we are not ad hoc, so we do not fall within the purview of the OM itself, my lord. Okay. In fact, that is, I molded the prayer that way, my lord, in my writ petition also, that we are outside the purview, we are not ad hoc, my lord.
Yes.
Now, my lord, I brought the old diseases, my lord, starting from Uma Devi and then ML Kesari, just to highlight one or two aspects of the matter, my lord.
Yes. Yes.
Well, Uma Devi, I'll refer to para 43, 47 and 53, madam.
Paras
43, 47 and 53, madam.
47?
Yes, madam. 43, 47, 53.
53 is exemption, is the...
53 is the famous 53, madam.
Yes. Yes.
Para 43 minute. Thus, it is clear that adherence to the rule of equality in public employment is a basic feature of our constitution, and since the rule of law is the core of our constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with requirements of Article 14 read with Article 16 of the Constitution. Therefore, consistent with the scheme for public employment, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee.
Yes.
So, my lord, there are two aspects to this. One is in accordance with the recruitment rules, my lord, and secondly,
yes,
proper competition among the qualified persons.
Necessary for public employment, the court, while laying down the law, has necessary to hold that unless the appointment is in terms of relevant rules
and after a proper competition among the qualified persons. Now, there is a requirement of recruitment rules, my lord, and the question is what happens when there are no recruitment rules, my lord? Then whether the past precedent, the past practice followed since the creation of the state of Meghalaya for last 50 plus years, my lord,
by executive instructions,
whether by executive instructions, that will cover the field or not, my lord. That's one aspect. Second aspect is this competition among the qualified persons, whether it refers only to through a recruitment advertisement or it will also cover the admission advertisement, my lord.
Please come again.
Second aspect, my lord, competition can be at two stages, my lord. One, while selecting the candidates for undergoing the course, my lord.
So that is okay then. And
because what the government's plea, it appears, my lord, is that there was no advertisement for recruitment as such. Now, our case is, my lord, advertisement for recruitment is one thing and advertisement for admission.
So you mean to say that advertisement for admission,
yes,
will suffice?
Will suffice, and I'll place
to be taken to be a
advertisement
calling for.
Yes, my lord. I'll place a decision of Allahabad High Court and Madras High Court, my lord. Allahabad High Court entered the decision in January 25, my lord, that Ayurvedic nurses in the state of UP, in fact, Allahabad has gone beyond, my lord, gone a step further, directing for their appointment, because state sent them, selected them through advertisement, my lord, for undergoing nursing courses in Ayurveda. They completed course, state took executed bond with them. Once they completed, state was not giving the appointment, my lord. Allahabad High Court has gone further, my lord, saying that this is a valid mode of recruitment.
No, but executing a bond doesn't give you a vested right to employment. Depends on the vacancies.
No, my lord. Allahabad High Court has gone beyond. I'll place the last judgment in the compilation, my lord.
Continue.
It has taken a different view, my lord. Now, so my argument basically, my lord, when there are no recruitment rules, we try to interpret the Umadevi judgment itself, my lord. So, whether past practice that is followed for 40-50 years of sending by selection to various courses.
The thing is that whether, you see, the basic thing it boils down to whether you were appointed or you have got employment through a selection process. That's all.
Yes, my lord.
If we can bring it down to that basic level, then whether there's any form of selection happened in your, and not that you have really a backdoor entry, go out to the back door again.
Exactly, my lord. So our case is, my lord,
so people, you say that
on advertisement, my lord. Pursuant on advertisement, they applied, my lord. There was a selection, maybe on the basis of class 12 marks itself, my lord. But there was a competition, my lord. They were selected on the basis of certain criteria, my lord, for undergoing the courses.
Okay. Yes. Continue.
Well, I'll continue with this paragraph.
Yes,
itself.
yes.
If it is a contractual appointment, the appointment comes to an end at the end of the contract. If it were an engagement or appointment on daily basis or casual basis, the same would come to an end when it is discontinued. Similarly, a temporary employee could not claim to be made permanent on the expiry of his term of appointment. It is also to be clarified that merely because a temporary employee or a casual wage worker is continued for a long period, for a time beyond the term of his appointment, he should not be entitled to be absorbed in regular service or made permanent merely on the strength of such continuance. If the original appointment was not made by following a due process of selection as envisaged by the relevant rules. Now again, it is temporary employee whose period of employment has come to an end, or of ad hoc employee who by the very nature of their appointment do not acquire the right.
It's not open to the court to prevent regular recruitment instance of temporary employees. Yes. Right.
The High Court's acting under Article 226. So, my lord, basically my stress was only on those two aspects, my lord, recruitment rules and competition among the qualified persons. Para 47. Where a person enters a temporary employment or gets engagement as a contractual or casual worker, and the engagement is not based on a proper selection as recognized by the relevant rules of procedure, he is aware of the consequence of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when appointment to the post could be made only by following a proper procedure for selection and in case concerned in consultation with the Public Service Commission. Therefore, the theory of legitimate expectation cannot be. So, in this case, my lord, the word used are contractual, and casual, my lord. Now, if we try to interpret the word, my lord, whether ad hoc can
temporary, contractual, or casual.
Temporary, contractual, or casual. Now, whether we fall in the definition of casual, we fall in the definition of contractual. My lord, contractual is very specific, my lord, appointment for a contract period of 3 years, 5 years, or 1 year. So we are not contractual, my lord. Now, whether we are temporary, my lord, whether our appointment order says that we are temporary, any of the appointment orders, my lord.
Yes.
And casual, whether we can be defined as or termed as casual workers, my lord.
So you say that the theory of legitimate expectation will apply to you.
Will apply to us.
Okay. Right.
Now coming to 53, my lord.
Yes. 1 second. Yes.
One aspect needs to be clarified. Para 53.
Yes.
There may be cases where irregular appointments, not illegal appointments, as explained in S.V. Narayanappa, Nanjunappa, and Nagarajana, and referred to in para 15 above, of duly qualified persons in duly sanctioned posts, might have been made and the employees have continued to work for 10 years or more, but without any intervention or orders of the courts or tribunals. So now in this sentence there are two, and this has been a subject matter of interpretation in subsequent decisions, my lord. Two conditions, my lord: sanctioned post and qualified person.
Yes.
So if we meet these two criteria, my lord, our appointment will be called as irregular, not illegal. The question of regularization of the service of such employee may have to be considered on merits in the light of the principles settled by this court in the cases above referred to and in the light of the judgment. In that context, the Union of India state government, that is instrumentalities, should take steps to regularize as a one-time measure the service of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of the court or tribunal, and should further ensure that regular recruitments are undertaken to fill up those vacant sanctioned posts and required to be filled up. So, my lord, what I am trying to submit from para 53, my lord, the Supreme Court in Umadevi laid down two criteria to term who are illegal. Basically, I am trying to explain or to submit, my lord, what is irregular and what is illegal. Now, illegal will be if it is sanctioned post and the persons are qualified. It will be called irregular, my lord. If they are not qualified or there is no sanctioned post, may be illegal, my lord. Now, our next decision is Puran Pandey. This came immediately after Umadevi, my lord. This is the case first diluted Umadevi, my lord, to some extent. I'll just take your lordship to paragraph 18 and 19, my lord.
Yes.
We may further point out that a 7-judge bench decision of this court in Maneka Gandhi vs. Union of India has held that reasonableness and non-arbitrariness is part of Article 14 of the Constitution. It follows that the government must act in a reasonable and non-arbitrary manner, otherwise Article 14 of the Constitution would be violated. Maneka Gandhi case is a decision of a 7-judge bench, whereas Umadevi is a decision of a 5-judge bench of this court. It is well settled that smaller bench decision cannot override a larger bench decision of the court. No doubt Maneka Gandhi does not specifically deal with the question of regularization of government employee, but the principles of reasonableness in executive action and the law which it has laid down, in our opinion, is of general application. In the present case, many of the writ petitions have been working from 1985, that is, they have put in about 22 years of service, and it will surely not be reasonable if their claim for regularization is denied even after such a long period of service. Hence, apart from discrimination, Article 14 of the Constitution will also be violated on the ground of arbitrariness and unreasonableness if employees who have put in such a long service are denied the benefit of regularization and, well, the last sentence is very important, are made to face the same selection which fresh recruits have to face. But the last sentence is what I'm trying to submit, my lord. We cannot be asked to
subjected to again sit for
a
exams.
recruitment where fresh graduates are sitting with us, my lord.
Anyway, this judgment is neither here nor there.
But only for this purpose, my lord, that this will be unreasonable and violative of Article 14 to ask us, my lord.
Okay, that part.
My lord.
Okay. Yes. Case 3, famous judgment.
Now, my lord, case 3, my lord, I'll refer to para 7 and 11, my lord. Now, para 7 tries to expand, my lord, to para 43 of the Umadevi judgment, my lord.
That 10 years.
No, 10 years and
yes.
Those two criteria, my lord, sanction post and qualified persons. Para 7 I'm reading on. It is evident from above that there is an exception to the general principle against regulation enunciated in Umadevi if the following conditions are fulfilled. The employee concerned should have worked for 10 years or more in duly sanctioned post without the benefit or protection of the interim order of any court or tribunal. In other words, the state government or its instrumentality should have employed the employee and continued him in service voluntarily and continuously for more than 10 years. The appointment of such employees should not be illegal, even if irregular. Where the appointments are not made or continued against sanctioned post, or where the person appointed do not possess the prescribed minimum qualification, the appointment will be considered to be illegal. But where the person employed possesses the prescribed qualification and was working against sanctioned post, but had been selected through undergoing the process of open competitive selection, such appointments are considered
without undergoing.
Such appointments are considered to be regular. So, my lord, we fall in this criteria. We can only be designated as irregular, my lord.
Case because you went through some sort of process.
Some sort of selection process.
Even because this 7.2 says selected prescribed qualifications, sanction posts.
So, my lord, sanction post and we are qualified, my lord.
But those are the two things that you're trying to bang on.
My lord.
The sanction posts are there, you're qualified, and so you have a vested right to regularization.
So we can at most be designated as irregular, my lord. We cannot be termed as illegal. And Umadevi says illegal cannot be regularized, irregular can be regularized.
Okay. Yes. 11.
Para 11, my lord. The object behind the said direction in para 53 of the Umadevi is twofold. First is to ensure that those who have put in more than 10 years of continuous service without the protection of any interim orders of courts or tribunals before a date of decision was rendered are considered for regularization in view of their long service. Second is to ensure that department instrumentalities do not perpetuate the practice of employing persons on daily wages ad hoc casual basis for a long periods and then periodically regularize them on ground that they have served for more than 10 years. Thereby defeating the constitutional or statutory provision relating to recruitment and appointment. The true effect of the direction is that all persons who have worked for more than 10 years as on 10/4/2006, the date of decision in Umadevi, without the protection of an interim order of any court or tribunal in vacant post possessing the requisite qualification are entitled to be considered for regularization. The fact that employer has not undertaken such exercise of regularization within 6 months of the decision in Umadevi, or that such exercise was undertaken only in regard to a limited few, will not decide entitles such employees the right to be considered for regularization. So, well, the state will take a plea that in 2022 they have regularized pre-2007, my lord. Now that will not preclude state from carrying out a second exercise, my lord. Now, my lord, next case is Narendra Tiwari. Here, what happened, my lord? Umadevi judgment is 2006, my lord. Jharkhand state came into picture, was created in 2000, my lord. So the issue before the Supreme Court was what will happen. They have not completed 10 years by then, because the state of Jharkhand itself came into being in 2000, my lord. So that 10-year date of Umadevi judgment was again diluted by this judgment, my lord.
Yes.
For para 8, I'll just read one.
Which paragraph from here?
Para 8 is the crux, my lord, in this.
A short judgment.
A short judgment.
Yes.
If a strict and literal interpretation, forgetting the spirit of the decision of the Constitution Bench in Umadevi, is to be taken into consideration, then no irregularly appointed employees of the state of Jharkhand could ever be regularized, since that state came into existence only on 15/11/2000 and the cutoff date was fixed on 10/4/2006. In other words, in this manner, the pernicious practice of indefinitely continuing irregularly appointed employees would be perpetuated contrary to the intent of the Constitution Bench. The High Court as well as the state of Jharkhand ought to have considered the entire issue in a contextual perspective and not only from the point of view of the interest of the state, financial or otherwise. The interest of the employees is also required to be kept in mind. What has eventually been achieved by the state of Jharkhand is to short-circuit the process of regular appointment and instead make appointments on irregular basis. This is hardly good governance. Under the circumstances, we are of the view that regulations rules must be given a pragmatic interpretation, and the appellants, if they have completed any use of service on the date of promulgation of the regulation rules, ought to be given the benefit of such service rendered by them. If they have completed any use of service, they should be regularized unless there is some valid objection to the regulation like misconduct, etc. So, my lord, here the Honorable Supreme Court diluted the 10-year as on Umadevi judgment, my lord.
No, but this is specific to Jharkhand.
This is specific to Jharkhand, my lord. Yes. But, my lord, what it lays down that Umadevi is not a hard and fast rule, my lord. It is subject to some other interpretation also, a contextual application of that, my lord. Now, next is a Madras High Court judgment, my lord, of 2009.
Yes.
Please give citation. Madras High Court judgment I don't have in the today's list of books which you have given.
There is no citation. I'll give a copy.
But I don't have that copy. Your title also, so that will help me. Title I can get it from the internet.
Title is G. Sujata versus Government of Tamil Nadu.
Year of the decision?
2009. 16/11/2009.
Yes.
Paragraph? Para 9, my lord. Para 9 is on 5th page, my lord.
Just a Chandru judgment. So just Chandru is different. Different doctrines altogether. Yes.
Para 9. In this context, Lordship,
yes,
it is necessary to refer to the earlier division bench judgment of this court in M. Elumalai and others versus Bhuvaneshwari and others. Para 9.
Para 9 says this submitted.
After that, in this context, that is a quoted parameter. The previous line. In this context, it is necessary to refer to earlier division bench judgment of this court in Elumalai versus so and so, wherein recruiting the stipend nurse in the regular employment of staff nurse was attacked by the candidates who had undergone training in a private nursing institution. The division bench, by its order, negatived the contentions raised by such petitioners. In paragraph 11, 23 and 24, the division bench had observed as follows. The entry into category of nurses starts with the admission into a government training school. It is composite scheme of recruitment, training and absorption exclusively for government institution. According to the state, if a person wants a posting in a government hospital, the entry point is an admission in the training institution run by the government, and there is no scope for any lateral entry. The candidates who succeed in the examination and are given training in government institution enter into an agreement to serve the government for a minimum period of 3 years after completion of the training. Therefore, the government provides these candidates rent-free quarters, free supply of electricity, paid stipend, which includes uniform allowance, and therefore public money is spent on them. The prospectus for admission also says nursing students who have successfully completed their training and obtained their diplomas will be eligible for appointment as nurses. The appointment cannot be guaranteed to all or any of the successful candidates. Recruitment will be made in accordance with the Tamil Nadu Medical Subordinate Service rules. Every year, 1795 candidates successfully come out of these government institutions, and there are more than enough candidates waiting for appointment in nurse post. The government is bound to protect these trainees as observed in 95 to SSC. Having spent public money on them, the absorption of these trainees students cannot be said to be unreasonable. It is open to the government to take a decision, and in fact, the Learned Advocate General fairly acknowledged that this code came into effect on a time when there were. This is not so relevant, my lord. I'll skip to next paragraph. The selection process was not in. Well, other paragraphs may not be that necessary. Basically, what Supreme Court Madras High Court Division Bench said, my lord, this is a composite scheme of recruitment, my lord. Selection through advertisement for undergoing the course, complete the course, execute a bond.
Now, in your case, all those people who went for training, they were given employment.
Mostly.
Whether some of them,
so some were not given appointment.
Some are given. So that means your contention that is selected has to be looked another light. If all people who were selected to go for the course or diploma were then on signing a bond given employment, then maybe we can be taken into recruitment process. But if some of them were not given employment,
but if posts are not available, my lord, that can be a relevant factor.
Then,
if the posts are not available,
that means that they would have acquired some vested right also. If you see the recruitment is a recruitment process, then why should it be left out?
But it will depend on available. But if posts are available, my lord, if posts are sanctioned posts are available, they cannot be denied, my lord. On merit, my lord, on the basis of merit.
So can it be a select list? Then can it be a recruitment? That's anyway. You continue.
But
that's just running in my mind.
The next Allahabad High Court judgment, my lord, this is more clear on this aspect, my lord.
Yes.
And this is a judgment, very recent judgment of January 25, my lord.
Allahabad High Court is also required. I don't have that citation, or I'm trying to pull that judgment also.
Neutral citations there. You give copy to them. Then.
If I can get neutral citation also, because my friend has supplied me citation of SSC, not of Allahabad. And
just take a.
Neutral citations there.
I could pull out all those judgments with SSC 1, but I didn't get these citations.
Yeah, what does it say? Paragraphs? Yeah, Dr. Mojika.
Well, at page 2, Lordship kindly see main para 2 and
is it number the paragraphs?
Yes, my lord. On second page, my lord, para 2 at the top, my lord.
Yes.
And then subpara 4, my lord.
Yes.
Below. But this is a description of the petitioners, my lord. The writ petition of Ms. Bhavna Misra bearing number so came to be allowed by the learned single judge by means of an order dated 7/1/2020. While allowing the writ petition, the order impugned passed by the Director Ayurvedic Service dated 25/9/19 was set aside, and a direction was issued directing the state respondent to consider the candidature of the writ petition for appointment as Ayurvedic staff nurse in a medical college, hospital or dispensary under the state government as per the prevalent policy which was being followed by the state government, and the state exercise was to be done within a period of 2 months. So, my lord, our case is more or less, since the creation of state of Meghalaya, my lord, the same practice is followed, especially in A&M, GNM and paramedics and some other posts also, my lord. So, same practice that select through advertisement for undergoing the course, my lord.
And on completing,
appoint them, my lord, on the basis of merit. as per the rank, as per this thing. Well, the submission of the state, my lord, at para 13 at page 5, my lord. The learned AG has ready-made submissions here, my lord. Learned AG can have ready-made submissions, my lord, from here.
Yes.
I don't have copy also, Mr. Dr. Mujika, which I assess the court.
It's okay. We're not concluding the hearing today. You'll have your enough ample opportunity to see, Mr. Advocate General. You have ample opportunity to rebut all these judgments that have been placed.
Yes, Lord.
Yes.
I would have.
So no worries, no worries. Yes.
Para 13.
Please continue, yes.
Leading the submission of the state appellant, the learned additional advocate general says so and so, duly assisted by so and so, additional chief so and so, has primarily assailed the order passed by the learned single judge on the following grounds. The alleged advertisement dated 23/9/13, by which the applications were invited from such candidates who desired to undergo Ayurvedic nurse training and having completed the said training, does not automatically oblige the state government to grant appointments, nor the advertisement indicates as such. The advertisement was for a selection of candidates for undergoing the Ayurvedic nursing training course, as was not for selection to the post of staff nurses. Simply, that the Department of Ayurveda Nursing Service Rules 2021 has been promulgated and are applicable to the writ petitioners. Once the said rules have been notified and are governing the field, hence the appointment of the writ petitioners can only be done in terms of the said rules. Merely successfully completing the Ayurvedic nursing training program does not assure the writ petitioners of government employment. As per the government order dated so and so, all such posts which with payment, this may not be so relevant, my lord. The next paragraph. In this light, giving a direct appointment to the writ petitioners would not be justified, and it will be against the public interest, as the other candidates who have completed their nursing training program from the different private colleges would be discriminated. Such an action, even if done under the order passed by the learned single judge, would be contrary to mandate of Article 14 of the Constitution of India, and this aspect has not been considered by the learned single judge while allowing the writ petition. Now, I will come to the finding, my lord. Para 17, para 16 onwards, my lord. The court has heard the learned counsel of the parties and also perused the material on record. At the outset, it will be noticed that the state had invited applications as per advertisement dated 23/9/13, which refers to the government order dated 12/11/1986. The said government order indicates that all earlier government orders shall stand superseded in order to bring about a qualitative change in the field of Ayurvedic and Unani treatment, and a fresh and complete selection process is being prescribed. The said government order further indicates that the candidate must undergo a written examination. Thereafter, the selected candidates will further be required to undergo an interview, and thereafter, the finally selected candidates will undergo the training. The record further indicates that all such candidates who cleared the training program successfully were given appointments by the government as per year and batch of such successful candidates. It is not disputed that the Uttar Pradesh Ayurveda so-and-so rules 2021 came into force for the first time on 18 November 21, and prior thereto, the appointments up till the year 2015 were being done as per the government order dated 12/11/1986. In the aforesaid backdrop, if the contention of the rival parties is examined, it would be found that there can be no dispute and quarrel to the proposition that any government order or service rules should take effect from the date of coming into force, and unless it is given a specific retrospective operation, till then the government order or the service rules would have prospective applicability. Upon perusal of the order passed by the Director Ayurvedic Services, Lucknow, whereby the representation of the writ petitioners was rejected, it would reveal that there were two grounds noticed by the said authority to reject the claim of the writ petitioners: that the service rules for the Ayush Department nursing service was under the active consideration of the state government, the pay band which is payable to the staff nurse had been enhanced, and upon such enhancement, the said post fell in the domain of the Uttar Pradesh so-and-so. Hence, the claim of the writ petitioner could only be considered as per the rules which was to be notified by the state. These two grounds per se do not inspire confidence or to reject the claim of the writ petitioners, for the reason that the applications for imparting nursing training was made in the year 2013. The writ petitioners were selected for undergoing the said training through the procedure as established in terms of government order dated 12/11/1986, and there is no dispute to the fact that all such candidates in the past who had successfully completed the aforesaid training were granted appointments in government hospitals and dispensaries on year and batch-wise principle. It is also not disputed that as per the advertisement, the successful candidates enrolled for the training of staff nurse Ayurvedic were also required to furnish a bond offering their service to the state for a period of 5 years, failing which the entire amount spent on the training of such candidates was recoverable along with interest at the rate of 12% per annum. It is also not disputed that there are 749 sanctioned posts of Ayurvedic nurses in the state of Uttar Pradesh, and year-wise vacancies for the recruitment year 11-12 till 17-18 had been indicated in the supplementary affidavit. So and so, so and so. But this may not be so relevant, my lord. Coming to para 26, my lord. It is in the aforesaid factual backdrop that the additional advocate of Sri Tripathi submitted that if the number of nurses enrolled is seen in context with the vacancies available, it would indicate that the enrolled nurses are much more than the vacancies. And in the aforesaid context, the advertisement of the year 2013 only invited applications for undergoing the training, but not assuring a selection for the post of staff nurse. In case if the appointment is granted to the writ petitioners, then it would be discriminatory so far as other nurses who have got themselves enrolled. It has also been explained by the learned AEG that earlier the training of Ayurvedic staff nurses were done by the state for which the applications were sought. However, later a policy decision was taken up by the government to permit the private college to offer such training. In this view of the matter, the state has to consider as and when the appointments are made for the post of staff nurse in terms of the service rules. The same has to be done through the Uttar Pradesh Subordinates Service Selection Commission, where all such nurses enrolled would be entitled to apply, and based on the said selection, the appointments can be made. The submissions made on behalf of the state at the first blush sounds lucrative. However, in light of the admitted fact that the rules came into force only in November 21, whereas prior thereto, till the year 2015, the appointments were made in terms of the government order dated 12/11/1986, and all such nurses who underwent training in the government medical college were accorded appointments. Hence, the rule of 2021 can only have prospective application, and the learned AG for the state could not demonstrate that the rule of 2021 have been given retrospective operation. That the submission made by the learned AG can hold good insofar as appointments to be made to the post of nursing staff with effect from November 21, but not for the writ petitioners, as their rights stood crystallized when they applied for the training of the Ayurvedic nurses training courses, and they were duly selected as per the government order dated so and so. Well, I'll read this entire judgment. The three. At this stage, it will be relevant to notice the observation of the apex court in the case of Begraj Singh versus so and so, and the relevant portion thereof is reproduced here under.
I think this case is directed. It was directed for the appointment.
Directed for appointment, my lord. It's gone to that extent, my lord. And here is a case we are already appointed, served for 15 years plus, my lord, regularized, confirmed with him, my lord.
Yes.
The quoted part, my lord.
And in this.
The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation, and the right to relief should be decided by reference to the date on which the petitioners entered the portals of the court. A petitioner, though entitled to relief in law, may be denied relief in equity because of subsequent or intervening events, that is, the event between the commencement of litigation and the date of decision. The relief to which the petitioner is held entitled may have been rendered redundant by lapse of time, or may have been rendered incapable of being granted by change in law. There may be other circumstances which render it inequitable to grant the petitioner any relief over the respondent because of the balance tilting against the petitioner on weighing inequities pitted against equities on the date of judgment. Third party interest may have been created, or allowing relief to the claimant may result in unjust enrichment on account of events happening in between, as the relief may not be denied solely on account of time lost in prosecuting proceedings in judicial or quasi-judicial forum and for no fault of the petitioner. A plaintiff or petitioner having been found entitled to a right to relief, the court would, as an ordinary rule, try to place the successful party in the same position in which he would have been if the wrong complaint against would not have been done to him. The rights of the writ petitioner in the instant case would have to be seen in the context of the advertisement dated 23/9/13 for the recruitment year 13-14. And the advertisement clearly provided a stipulation that all such candidates who were selected for training would have to offer their services to the state government for a period of 5 years, failing which the amount spent on training was recoverable with interest at the rate of 12% per annum. This condition apparently was not a part of any application which were invited by private colleges. In any case, it was subsequent to the advertisement which was published on 23/9/2013. The private colleges have their own methodology of selection, even though they prescribe the same qualification for the candidates as may be the state government operated colleges. However, all such candidates who offer rigorous screening and undergoing the selection process as per the government order dated 12/11/86 and thereafter successfully complete their training constitute a class separate candidates to those candidates who undergo the training programs as offered by the private colleges. In the aforesaid backdrop, where the state had been making appointments from amongst those candidates who applied for and were imparted training through the state government college on a year and batch-wise basis, and in the absence of any statutory rules, the same cannot be deviated without any justifiable reason. As noticed above, the rules came into force only November 21, and therefore prior thereto, the practice followed by the state for a sufficiently long period cannot be ignored. It is tried, Lord, that the validity of an order is to be seen on the basis of reasons incorporated therein. So, para 37, 38. The learned single judge has considered the aforesaid aspect and has noticed that in the absence of the rules, the appointment could not be refused simpliciter as the rules were still in the process of being framed and notified, whereas there was a settled practice which was adopted by the state for decades as per the government order, which itself was incorporated in the advertisement, which clearly gives a legitimate expectation to the candidate that in case a candidate is selected and successfully completes the training, then she has right for being considered for appointment. Moreover, the vacancies do exist and the reasons as mentioned in the order impugned in the writ petition are unsustainable. Hence, it has been rightly set aside by the learned single judge.
Yes.
So, my lord, this more or less
covers your case, you say?
Covers my case and answers all the possible objections that may come from the state government, my lord. Now here only one aspect, my lord, as far as nurses are concerned, my lord, from the year 2013 onwards, this process has been abandoned, my lord, this method.
Which are calling for bond?
Sending for training, my lord.
Now your petitioners like
they open advertisement,
who has served the longest and who served the shortest from this batch of ENM and GNMs?
My lord, since 2007, my lord, many of them. And the last one is more than 11 years, my lord.
Last 11 years. So 2007, that means 19 years.
None is less than 10 years, my lord. We have kept them out, my lord. All have completed 10 years plus. Okay. And the maximum is still. Now, my lord, one aspect is very interesting here, my lord. Umadevi, they say that pursuant to Umadevi, they have carried out one-time exercise, my lord. Umadevi said those who completed 10 years of service as on the date of Umadevi judgment. So that will mean, my lord, only those who were appointed prior to 96.
Yes.
They completed 10 years in 2006, my lord. Yes. Only they could, my lord. I have papers, my lord. Persons who were appointed in 2006, my lord. And 2007. Only on completion of 3 months service, my lord, were regularized.
Okay, doesn't matter.
So we don't gain any advantage out of that, my lord. But it's just to point out, my lord, that the state is not following the Umadevi principle. But they are not following for that purpose, my lord. And Umadevi is not a bar for us.
No, if they appointed after 2007 also, the thing is that why did they engage in exercise if they are sanctioned force? If the prescription of Umadevi was to stop this kind of ad hocism and this, stop, that everything, what this 7 judges thought that, by this landmark judgment, like it'll put, like a watershed moment in,
yes, my lord,
like in the services.
And there will be no further such appointments.
Can be in certain circumstances, but then generally the rule.
But not for perennial duties, which are essential to the department. Yes, they could not have been appointed.
That the state authorities, they engage in a regular selection process. But even forget Umadevi, even I think state government also since 1989 or 1990 have been issuing memorandums that should not be any more ad hoc appointment, correct?
Yes.
Against sanctioned posts, but been continuing. So they have engaged in that exercise. So also cannot ignore also that the rights, what kind of rights are vested with the people who have been appointed by this informal system.
Now, well, their office memorandum from 1989 says don't make an ad hoc appointment, my lord. Now I am on the very root of the matter, my lord. Are we ad hoc, my lord?
Exactly. That's why this case is very important. Because ad hoc, that's why the charge is important as the nature of duties.
Yes, my lord.
Whether it's substantive in such a way that your services are required.
But very essential duties, my lord, all are so essential to the department. Department cannot even function without those employees, my lord. Nurses, my lord, health department cannot function without nurses, my lord. Paramedics, the health department can function. Weaving inspector, weaving demonstrators, my lord. The sericulture department cannot function without them, my lord.
How many of these weaving inspectors are there before this court is badge petitions?
Number 10 or 12, my lord.
And the others. Anyway, we'll look at the chart.
My lord.
Yes, any further submissions to make for today?
Now, my lord, now my next submissions were on only on the basis of chart, my lord. I'll point out what is the nomenclature of the appointment, my lord. Except maybe one or two, all appointments are, no, there is no mention that it is ad hoc, my lord. 99%, some are officiating, my lord. Now, what is officiating? I'll place the decision also.
Officiating also you have to place decisions.
Well, Supreme Court says
officiating, ad hoc.
But officiating Supreme Court, I'll place the decision, my lord. It says when a person in a substantive post discharges the function of higher post, my lord.
Not really.
Yes, my lord.
It can't be such a such a tight definition, because officiating also sometimes even a person goes on leave for a long period. Someone else is put officiate against that post also.
So, my lord, officiating can be someone who is already in the
someone
department.
suffering from terminal illness, like cancer or something, can't discharge the duties, then someone officiates against that post. So whether it can be just confined to that you officiate against higher post.
But
and then
except
the other questions, appointment against leave vacancies, that's a different area altogether.
But the
officiating, I understand what you're trying to say is, suppose
chief engineer post is
executive engineer,
vacant.
he's the student engineer's post is empty in a certain division. Then the executive engineer is asked to officiate against the post of an engineer.
He gets some extra pay for that.
He may get extra pay, might not also. He'll get, so that's the thing. But in other cases, they pay officiating pay also. Sometimes they picked up from the street also to officiate against the post. And then.
So, my lord, my endeavor will be to categorize into three categories, my lord, all the posts. A&M, GNM, paramedics, they are all together on different footing. Second category will be those who were sent for training for undergoing textile technology courses, my lord, were appointed in weaving and sericulture department. They are also selected through advertisement, my lord. Sent to seats reserved for state government, my lord, state quota seats.
Okay, we'll conclude for today. When should we resume this hearing?
5 minutes, lordship. I'll just read your comment.
You're not concluding the hearing. You have your hearing. Let Dr. Mosika conclude his part. Then we'll hear you. Then we'll hear the Advocate General. Mr. Paul also is in the mix, no? In this case,
I'm not on that. I'm not item the next item.
Right.
Lordship, one aspect, Lordship, I wanted to highlight is in these kind of cases, Lordship, in other cases, what happens is that the state takes the decision of financial constraint, Lordship. Because
we're not them. They can't. Finance constraints cannot be considerations of constitutional authority. A state cannot say. Then if you say you have finance constraints or you can't employ them, that means it's a breakdown of constitutional machinery.
That will not come here because all of them are on a regular pay scale, my lord.
Dharam Singh and others, they were
when should we,
equal pay.
Mr. Advocate General, when should we resume?
Monday or Tuesday?
Dr. Mujka has to prepare the chart, my lord.
By Monday? Monday shall be ready.
Monday will be difficult, my lord. Monday
Tuesday then. Oh yes.
Next week there will be some difficulty, my lord.
Oh yes.
Next week I have difficulty. On next week thereafter, if my friend can prepare the chart 28th, he can give the.
They will have it on. We'll have it on 3rd.
3rd December.
Yes, sir. Matters apart. Yes, this for further hearing on 3rd. Counsel for the petitioner to prepare the comprehensive chart. Yes.
Hearing?
Interim orders are already till further orders.
Interim for orders.
Hearing? Item 103.
Item?
103.
Yes. Yes.
Well, it's item 103 and 104.
Yes.
These are the matters concerning the VC elections. If your lordship should recollect, on an earlier occasion, we had pointed out that there were certain anomalies. Now, in these matters, my lords, what had also fallen from my lords, and it was a suggestion that we had given at that stage, that it would be expedient, my lords, that your lordships fix certain guidelines insofar as these VC elections are concerned. Because every time, my lords, there's some election, either pre-election or post-election, my lords, somebody is coming before this honorable court, and anomalies are being brought out. Let's say your lordships would recollect in one of these
There
matters
is
being
no
brought out
anomaly, my
that some
lord.
people
The
were there.
candidate has lost by 100 votes, and the state
Yes,
and
again,
elected
there's
body
no
was
question of my
elected
learned
body is
friend is
not
just
allowed to
interjecting
concede, my
without
lord.
even knowing what the facts of this case is.
My lord,
Only
because
what
that
I'm
is why when
saying
we don't have facts, we will talk about law, my lord.
Yes.
100 votes. The petitioner has lost not less than 100 votes, my lord. And there is a stay, my lord, and elected body is not allowed to function because of the lordship. Kindly hear this matter on next.
Yes. Yes. This was since last year.
November, last year, November, my lord.
Yeah.
30
November
was
last
the
year.
election. Yes, my lord.
Yes. You start. What's the timer? Yes.
What?
Yes.
I'm sorry, Milord.
Yes. So you present your case. Oh, Mr. Apkajal, looking for another date. I couldn't understand just now. You made some submission, Mr.
Yes, I was saying, my lord, that
Yes.
this case requires some urgent hearing, my lord, that the candidate, the VEC, my lord, the candidate has won by more than 100 votes. The losing candidate, my lord, on some flimsy ground has said that there is no verification, everything was carried out, and then the lordship has passed the interim order not to give effect to the election, my lord. So therefore, I am ready, my lord, I can argue today and the matter can be over, my lord. That's what I was saying.
Yes. Yes.
One zero
Tomorrow.
I'm sorry, Milord.
Tomorrow then.
Let it be on Monday, Milord. Tomorrow there'll be some difficulty. I'll have some difficulty. Let it be on Monday. Milord.
Okay, Monday.
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 Monday will be on 104 both.
Something's wrong. Yes. Both the matters.
May I have it on Tuesday?
Okay, Tuesday.
Tuesday or Friday, my lord. Lordship, may I request for Friday, my lord, next Friday.
That means tomorrow.
Next Friday.
Next Friday.
Senior is asking.
Do tomorrow. Yes, Mr. Paul.
I have some difficulty tomorrow, Milord.
Why? Where is he? Where are you right now?
My lords, I am in Delhi.
The way the wall are behind you looks like you're in detention somewhere. It's blank. Yes. Right.
I would have started, but there is a difficulty with because I'm required to travel somewhere, and I'll not be available tomorrow. So if my lords kindly have it next week.
Okay, we'll have it on Wednesday. Yes.
Oh.
Yes.
Next Wednesday, my lords.
Yes.
Obliged.
Coming Wednesday.
Daily list 29.
Mere Lordship.
Yes.
My lord, kindly see the last order, my lord. This is the matter pertain to the benefit of MACP and ACP to the cipher category, my lord. And the last occasion, my lord, they have also placed.
Yeah, Dr. Mojika, what instructions do you have specific?
My lord, this is under active consideration, my lord.
Yes?
This is under active consideration, my lord. Some more time is given, my lord. Maybe
after 2 weeks you come back, yes.
It also gives me 3 weeks.
Dr. N. Mojika submits
here also
the
several
matters
petitions are
under
there.
active consideration
3 weeks time.
for compliance. Yes, sir, list after 3 weeks.
My lord, much appreciated.
2 o'clock division bench, I think, anyway. Yes.
Item number 1.
Scheme for newly. Where's Mrs. Dasgupta?
Is on leave, Your Lordship.
On leave?
Yes.
Lordship, I'm praying for some time to file our affidavit.
Lordship, in the meantime, interim may continue.
So when? How much time?
1 week.
3 weeks' time, Lordship.
Yes, MS Emricham Leonard, Council Vice Dr. Mosgaja prays for allowed for the 3 weeks time to file affidavit. And this thereafter also interim orders continue in the next 8 days.
Highly obliged.
Hearing. Item number 2.
Your Lordship. So I'm paying for
Ready?
some accommodation in this matter. I'm appearing on behalf of Mr. R.B. Popan. He has some
happened?
personal difficulty, my lord. Under his instructions, it may be kindly be. I'm praying for this matter to be taken up after the vacation, my lord.
After vacation?
Under his request, my lord.
Interim orders continue after vacation. Yeah,
we've
objection,
informed
MS Lalu.
No objection, Lordship.
No objection.
Lordship, this matter is led by Mr. Ensign
I've
so he's
informed-
having
I've
some
informed
personal
him.
difficulties.
Okay, on the request of the council of the parties, list the matter after winter vacation. Interim orders, if any, continue until further orders.
Much
Much
obliged.
obliged.